This is the case of Plyler versus Doe. The essential question it answered was, can the children of illegal immigrants be denied access to public education? The origins of this case take place in Texas. In 1975, the Texas legislators revised and enacted Section 21.031 of the Texas Education Code. This code withheld state funds to public school districts for the education of undocumented children and permitted school districts to deny enrollment or charge tuition to undocumented children. Due to state funds being withheld, 2 years later, in 1977, James Plyler, who was the superintendent of the Tyler Independent School District, adopted policy to require an annual tuition of $1,000 to undocumented students. In response to this policy, 4 families filed a class action lawsuit challenging James Plyler and the Tyler Independent School District. The families were given permission to remain anonymous under the name Doe, and were represented by the Mexican American Legal Defense and Education Fund, or MALDEF. In order to demonstrate a substantial state interest or legitimate reason for the Education Code, Plyler and the state of Texas provided the court 3 main arguments. Firstly, they claimed the Equal Protection Clause did not apply to undocumented people. Secondly, they argued that children who needed help learning English or were often behind in their schoolings were expensive to educate and were taking resources away from children who were in the country legally. Thirdly, they did not want free education to incentivize people to come into the country illegally. In 1978, Federal District Court Judge William Wayne Justice ruled in favor of the families, stating that the Texas Education Code was unconstitutional under the Equal Protection Clause of the 14th Amendment, which states, "Nor shall any state deny to any person within its jurisdiction the equal protection of the laws." Furthermore, Judge Wayne Justice was not convinced the schools could save much money by excluding these children. He even pointed out that the families paid property and sales tax which supported schools. He argued in the long run, denying these children education would not save more money. He wrote, "Already disadvantaged as a result of poverty, lack of English-speaking ability, and undeniable racial prejudices, these children, without an education, will become permanently locked into the lowest socioeconomic class." In 1980, the Tyler Independent School District appealed to the U.S. Court of Appeal for the Fifth Circuit. However, the appeals court also ruled in favor of the families. Unhappy with this decision, the state of Texas stepped in and appealed to the U.S. Supreme Court. In 1982, in a 5-4 split decision, the U.S. Supreme Court ruled in favor of the families, affirming once again that the Texas Education Code violated the Equal Protection Clause of the 14th Amendment. The court found there was no substantial interest to justify the state's education code, instead finding their previously mentioned argument irrational and unsupported by evidence. The majority opinion author, Justice William Brennan, wrote, "By denying these children a basic education, we deny them the ability to live within the structure of our civil institutions and foreclose any realistic possibility that they will contribute in even the smallest way to the progress of our nation." It's worth noting that the opinion of the dissent, written by Justice Warren E. Burger, did also agree that it was not good policy to deny any child an elementary education. Their concern, however, was that this issue was not one for the courts and should be handled by the legislative branch of government, not the judicial branch. Over the decades, there has been numerous attempts to challenge or weaken the decision of Plyler, including California's Proposition 187 in 1994 and Alabama's House Bill 56 in 2011. Even as recent as 2025, a number of states have proposed legislation directly challenging the decision of Plyler. With that said, there are estimates that hundreds of thousands of children have received an education thanks to the protection of Plyler, which also prevents schools from inquiring about a child's immigration status. Children from the original 4 families, like Lydia and Alfredo Lopez, are now citizens, along with their parents. According to MALDEF, the Plyler decision has played a key role in making undocumented children eligible for DACA, the Deferred Action for Childhood Arrivals, established in 2012. For over 40 years, the decision of Plyler has remained law of the land and continues to be a strong barrier to provide all children access to a free K-12 public education. These are my sources. Thank you for watching.